Welcome and thank you for joining us for Your Child with Disabilities is Turning 18, Legal Decision Making for Young Adults Who Need Assistance. My name is Ashley Greenberg and I'm an attorney at the Northwest Justice Project, and I'm joined by my attorney colleague, Kate Lehner. Today we'll be discussing options for legal decision making, which include guardianship and conservatorship, power of attorney, and other decision-making options that you may be less familiar with. Please note that this presentation is for general information only and is not legal advice. Kate and I would like to just take a moment to say, why are we giving this class? And so we often speak with parents of young adults with disabilities who are turning 18. And in those situations, the parents have been helping their children since they were babies. And then children, deal with school, deal with maybe their financial benefits, with medical providers, communicating with all of those parties, really supporting their young person and making decisions. And then once their young person turns 18, they're really nervous that things are going to change about how they're able to offer that support or help their loved one with making decisions. Why is that? So the law presumes that people ages 18 and over have the capacity to safely make their own legal and medical decisions. When we use the word capacity, what does that mean? Capacity means that someone can take in and process information, understand the effect of a decision, and communicate their decision to others. However, sometimes when a young adult with disabilities is turning 18, they need help making decisions. And so what are those options? And what can parents or other trusted adults do when their young person with disabilities needs help making decisions once they turn 18? The types of options that we're going to talk about today are both court options. They're in that orange box on the left side of your screen. So those are options that involve a court process, like guardianship and conservatorship that you may have already heard of, and then also protective arrangements and emergency guardianship that you might be less familiar with. And then there are also options that don't involve a court process, such as durable power of attorney, supported decision-making agreements, Washington State's informed consent law for medical decisions, and then protective and representative payeeships. We'll be discussing all of these options today.
Thanks, Ashley. I'm going to start out talking about some of the options that require actually going to court, filing papers with the court, and bringing a court action. Next slide. So we thought it would be helpful to step back first and talk about the definitions of some of these terms. A lot of them are terms many of you watching this are probably familiar with, but it's helpful to step back and really look at what they mean. So first, we wanted to look at what really is a guardian. So a guardian is a person that the court appoints to make decisions on behalf of a person with disabilities. And the types of decisions that the guardian may be able to make on behalf of the person with disabilities includes decisions related to the person's health and safety, their education, their housing, and their personal care. Next slide. So it is important to keep in mind that guardianship and conservatorship, these are legal processes, and there are laws in Washington State that talk very specifically about when a court can appoint a guardian or a conservator. And all of the elements that are set forth in the statute do need to be met in order for a court to be able to appoint a guardian or conservator. So in order for the court to appoint a guardian, it needs to be shown that the person can't meet their basic needs for physical health, safety, or self-care, that they can't receive or evaluate information or make or communicate decisions even with some type of help or support, that a guardian is needed to prevent significant risk of harm, and that the person's needs can't be met by less restrictive alternatives. Next slide. So a conservator is somewhat similar to a guardian, but this is someone who the court appoints to make decisions on behalf of a person with disabilities about the person's money or property or resources. Under prior laws, this was referred to as a guardian of the estate. So some people watching may be familiar with the term guardian of the estate, but that changed in January of 2022 when there was a change in the guardianship laws in Washington state. Next slide. So the standard for the court to be able to appoint a conservator is that the person can't manage their property or finances. They have limited ability to receive and evaluate information or make or communicate decisions, even with help or support. A conservator is needed to prevent harm or loss of property, or to get funds that the person needs for their support or other needs. And the person's needs can't be met by less restrictive alternatives.
So, Kate, I know that we just wanted to take a minute to talk about some common questions that we've received over the years when we've given a very similar presentation about guardians and conservators in general and how they make decisions, what kinds of decisions they can make, and really just kind of understand the practicalities of all of this a lot more. So, to kick that off, how does someone know what types of decisions a particular guardian or conservator has in relation to the person over whom they have guardianship or conservatorship?
So in order to determine that, you have to look at the actual order of guardianship or conservatorship that the court has entered. And that will set forth information about specifically the types of decisions the guardian or conservator can make on behalf of the person.
My next question is, what if a person with disabilities needs a guardian or conservator for some types of decisions, but not for others? Is guardianship or conservatorship, is it really kind of a one size fits all, or can it be tailored or really kind of made and constructed to the needs of that specific person with disabilities?
Yeah, it's a very good question. And it absolutely can be and actually should be tailored to the needs of the person. So the court can enter an order that's either a full guardianship or conservatorship or limited. And what that means is if it's full, then it restricts or takes away all of the rights that can be restricted under the laws and gives authority for all those decisions to the guardian or conservator. A limited guardianship or conservatorship only restricts certain rights and gives the guardian or conservator the ability only to make certain types of decisions on behalf of the person.
So, would an example be then like if someone needed help with financial decisions, but maybe they were able to make medical decisions or something, just to say that, then how would that work? How would that play out in practice?
So it's possible then that in that case, a conservatorship alone would be sufficient, or it may be that a guardianship would still be needed just for certain types of decisions, but perhaps not medical decisions.
Okay, that makes a lot of sense. Once someone is a conservator or a guardian of another person, um, are there any sort of guidelines about how they're supposed to make these decisions? And are there any sort of duties that they have to that person with disabilities over whom they have guardianship or conservatorship?
Yeah, so the guardian or conservator has to try to make decisions based on what the person with disabilities would choose for themselves. And if the guardian or conservator is unable to do that, then they need to try to make decisions based on what would be in the person's best interests. In addition, both a guardian and a conservator have what's called a duty of care to the person, and a fiduciary duty. Particularly conservators have a fiduciary duty. And what those things mean is that there's a duty to make sure that the person's needs are being met and to make sure that any income or resources that they have are being managed responsibly and are just being used on behalf of that person. So in other words, to meet that person's needs.
And before I go to the next slide, the final question that I know that we receive sometimes is, if there is a guardianship or conservatorship in place, but either circumstances change or for whatever reason, someone thinks, do you know what? Probably a limited guardianship or conservatorship that you were talking about, that would probably serve the purpose instead of a full, or maybe there doesn't even need to be a guardianship or conservatorship anymore. What does that look like when it seems like there could be some sort of a change or an end to a guardianship or conservatorship? How does that get kicked off that would even come to the court's attention?
So the person who is subject to a guardianship or conservatorship, or really any person who is interested in the well-being of the person who's subject to guardianship or conservatorship, can contact the court. They can just write a letter to the court. It's nothing particularly formal, and ask the court to look into it. And the court then is required to look into it, to schedule a hearing, and to figure out whether guardianship or conservatorship is still needed, whether it could be reduced to limited guardianship or conservatorship, and whether other less restrictive alternatives would be sufficient. In addition, as we'll talk about in a minute, guardians and conservators have to file periodic reports with the court, and the court look at those reports at any time and decide, it looks like maybe this person doesn't need this guardianship or conservatorship, and let's take a look and see if another less restrictive alternative would be sufficient to protect the person.
Great.
Okay, so in these slides, we just wanted to be really clear that we're not trying to provide like a step-by-step set of instructions on how to file a guardianship or conservatorship. This is really meant to be a very broad overview of the process. We thought we would include this because people often have some basic questions about the process and want to understand sort of generally what it looks like. And there's also certain steps or aspects of the process that we really feel we wanted to highlight. So I'm going to go through some of these. One thing to be aware of is that if the person who wants to be a guardian or conservator has to take an online training, and that training is really important because it talks about what are the duties and responsibilities of a guardian or conservator. And that is required as part of the process. Now, the first sort of step in filing is that the person who's submitting the action to the court, who's referred to as the petitioner, fills out and files forms with the court, and that the initial form is actually called a petition. The petitioner isn't necessarily the person who's seeking to be the guardian or conservator, but they can be. In cases that we see, usually it is the same person. Once that case is filed with the court will appoint a court visitor. And the court visitor's role is to gather information, to kind of investigate further, and to file a report with the court, to give some background information for the court and to provide some basic recommendation on whether guardianship or conservatorship is appropriate and whether the person seeking to be the guardian or conservator is an appropriate fit for that. So the court visitor will do things like they do have to go and speak with a person with disabilities and try to explain the process to them and get a feel for whether they're understanding things. They have to talk with the proposed guardian or conservator, and then they'll talk with third parties who have knowledge. So it might be family members, teachers, and so forth, who know about the person with disabilities and kind of paint a bigger picture. And then the court visitor also is responsible for getting an evaluation from a medical professional that can speak to the person's medical conditions and conditions that might impact the person's cognition and so forth. One thing that's important to understand is that the petitioner does have to deliver in very specific ways copies of all the legal forms that are filed with the court to the person with disabilities and to certain other people under the statute. Sometimes people have asked us, is this really necessary? They're not going to understand the paperwork, but it is absolutely required. And it's because that person has the right to see that paperwork and to respond if they want to, and to object if they want to. So that is a very critical piece of the process. So once the case is filed, the court will hold a hearing approximately 45 to 60 calendar days after the petition is filed. That period is set by statute. So that's required unless the court grants an extension for some reason. And then there'll be a hearing where the court will decide if guardianship or conservatorship should be approved and whether the proposed guardian or conservator is appropriate for the role.
Kate, may I ask you, in terms of both that petitioner who files those forms to start the case and then also the proposed guardian, are there any special qualifications that people need to have or requirements beyond this training, of course, that you've already mentioned that they need to have in order to either file that petition or to be a proposed guardian?
Yeah, so there aren't specific qualifications. However, there are some reasons that a person may not be allowed to serve. So one question we do get frequently is whether a proposed guardian or conservator has to have, or the person who wants to file the forms with the court has to have legal immigration status. And the answer to that is no. There's no requirement that a petitioner or that the guardian or conservator have legal immigration status in the country. So that's important to understand. However, there are some other basic qualifications to know about. In general, the proposed guardian or conservator has to be at least 21. There's a few exceptions to that, but that's the general requirement. The person has to disclose any criminal history to the court, and there are certain types of criminal convictions that can bar the person from being able to serve, although again, sometimes there are some exceptions that can be made. And in addition, the person or the proposed guardian or conservator has to disclose any bankruptcy filings. And again, that doesn't necessarily mean that they will be disqualified, but that is something the court will be looking at. And then just generally, the court does get to make an overall decision about whether this person is suitable to serve as guardian or conservator. So this slide talks about the steps after the guardian or conservator has been appointed. We thought this was really important to include because I think sometimes people have an idea that like once the court grants it, then basically you're done. And that is really not true. This is an ongoing process that requires ongoing reporting to the court. And so people need to understand that it doesn't end with that hearing and that order. So first of all, the guardian or conservator does need to file a form with the court called acceptance of the appointment, which just says, yes, I accept this, I'm willing to serve. It's very basic. The court will then issue what are called letters of guardianship or conservatorship. They're also sometimes called letters of office. And these are the documents that guardians and conservators need to show to third parties like financial institutions and medical providers as proof of their current authority to make decisions on behalf of the person. The guardian or conservator has to give certain notices to the person with disabilities once they've been appointed. And then they do have to file a series of reports with the court. So the first report has to be filed within 90 days of the appointment. But then after that, they have to file reports with the court every year. And if they don't file their reports timely, the letters of guardianship or conservatorship will not be renewed by the court, and they won't have that current proof of their authority to make decisions. And then in addition, the court can require a hearing and basically say, hey, this is required. Why haven't you filed? So it's important for people to understand this is a really important responsibility. And this is basically to allow the court to continue to monitor the guardianship or conservatorship to make sure that the person's needs are continuing to be met.
And Kate, let me ask you two more questions, and this applies both to that filing for guardianship or conservatorship process and then this whole reporting process. And these are questions that I know that we often get. So the first is this whole processes that you're talking about. Is this the exact same process and forms and everything like that all over Washington state? Does it differ county by county? How does that work?
So there is a Washington state, a set of Washington state guardianship laws, right? So those apply to all cases that are filed wherever they're filed in Washington state. And there are standard forms that can be found on the Washington court's website. We do have a link to that on our resource page at the end of this presentation. But it is also true. So guardianship and conservatorship cases are filed in the Superior Court of the county where the person with disabilities lives. And each Superior Court may have its own additional forms that it wants people to use. And it also might have its own very specific and more detailed procedures that it wants people to follow. So people should really contact the clerk of the court of the Superior Court where they're filing and look at the website and so forth in order to see if there are some specific local filing requirements.
Okay. And the other major question that we get about these processes are, do you have to hire a lawyer or can you do it yourself? And then in terms of resources, are there free legal resources for court representation, either free or not as expensive for low or moderate income people?
Yeah, so it's not required that a person have an attorney in order to file for guardianship or conservatorship. But it is, a legal process. It can be complicated. The steps that we've shown here are not all the steps that are required. And so, we generally think it's a good idea for people to have an attorney if at all possible. Unfortunately, in terms of free legal representation, there's really not a lot in the way of those resources around the state. We do see many families do decide to hire an attorney to help them through the process, but that's not required. In terms of other resources, I'll just note that in some counties, the family court facilitator who works within the Superior Court is sometimes available to review the forms before the petitioner files them, basically to make sure they're complete. The facilitator can't provide legal advice, so they're not in the shoes of a lawyer, but they can at least make sure that the forms look correctly completed. And then finally, in some counties, there are guardianship monitoring programs, which are programs that help the guardian or conservator file those periodic reports that I talked about. And that can be a very helpful resource. So again, you can check with the clerk of the Superior Court, or you can look on the website and see if those resources might be available to you. So it's important to understand that under the law, a court may not appoint a guardian or conservator if the adult's needs can be met in other ways. So you have to look at less restrictive options first. And this goes back to that change in the law that I referenced previously, that in January of 2022, there was a major overhaul to the guardianship and conservatorship laws in Washington state. And this was really part of a nationwide movement to try to maintain to the greatest extent possible the autonomy of people living with disabilities. So there really has been this push to overhaul the laws to try to avoid guardianship or conservatorship where possible, and to make use of other options that maintain the person's rights and their autonomy. Next slide. So the court will ask a petitioner what else has been tried in terms of legal decision-making options, some of the things that Ashley is going to talk about in a minute. And the court can dismiss the petition if there are other options that could meet the adult's needs. And I'll just note that even on the petition itself, there's a space where you have to provide information about what other options have been tried, why they haven't worked, or why they haven't been tried, and so forth. Next slide. So if you're thinking about filing for guardianship or conservatorship, you really have to go through these questions to determine whether it's the right option. So first you look at, well, what's the problem? Is there an actual risk of personal harm to the person? And or is there a risk of financial harm to the person? Next slide. And if there is a risk, then there's the second part, which is, can guardianship or conservatorship actually solve the problem? And so it's important to keep in mind that guardianship or conservatorship alone will not automatically make a person with disabilities safe. And, you know, we've seen this, that I think there's a common sense of sort of like, if I just get that order, it's sort of this cone of protection around the person, they're going to be safe now. And it's really more complicated than that. You know, it is one tool, but you need to think about other forms of support, other social supports, other services, other trusted adults that can provide support to the person when they need it. And a guardianship or conservatorship alone is really not sufficient. And then it's also important to keep in mind that it's not appropriate if it's just that you don't agree with or would make different decisions than the person with disabilities. And it's hard, you know, when your child turns 18, it can be challenging. They might make decisions that you're not comfortable with as a parent, but that alone is not sufficient for guardianship or conservatorship. You really have to go back to the standards that I talked about to see if the requirements of the statute are met.
So, Kate, I pause and just for a moment here and ask you, because I know that we've gotten this question a lot when we presented this class in the past and when we've spoken to families. You know, the basic question here is, and it comes from parents who love their children so dearly, have been so involved in these decisions for very, very good reasons. But their child is now turned 18. The child is an adult in the eyes of the law. They have that capacity to make their own decisions. And the parent or trusted adult says, but my child thinks that they should make their own choices. And I don't think that they should make their own choices. And I know that's sort of the ultimate issue of what we're talking about today. But what are your thoughts about that?
Yeah, and it really is the ultimate issue. And it's a little hard to speak to because it is very individualized. And it really, you know, you have to look very closely at the individual circumstances in each case. But what I would say again is that you really have to look back at the statute. You have to look at the standard for when a court can grant guardianship or conservatorship. Are all those elements met? And you know, you could use this as an opportunity to try some less restrictive alternatives, which Ashley is going to talk about here. You know, and the fact that the young person is saying they feel they should be able to make their own decisions might be an indicator that they are capable of engaging at some level in decision making. And so, you know, it might be a good time to have a conversation about, you know, understanding that they want to make their own decisions. Would they accept help with certain types of decisions? Would they be willing to have some kind of support? And that might be a good starting point for talking about some of the less restrictive alternatives. Okay, so we do get this question too, where parents are quite worried because, or other family members, because they say, and this young person in our family is turning 18. We're worried. We don't have any guardianship or conservatorship order. Is something really bad going to happen once they turn 18? And what we can tell you is that in most cases, there's no major change that happens immediately after the person turns 18. So, for example, many medical providers are willing to continue to provide care under that informed consent statute that Ashley will talk more about. So usually people can continue to get the medical care that they've been receiving. If it's an option for your family, again, you can try those less restrictive options. And then finally, if a need came up that was kind of urgent after the person turned 18, there are a couple of other court options that might be helpful as a stopgap. So one is an emergency guardianship. This is a type of guardianship that is limited in duration. It's generally for 60 days only. But you can get it more quickly than you can get a regular guardianship. And so if there's kind of an urgent need, that might be helpful. Another option is a protective arrangement. A protective arrangement is similar to guardianship, but it is more limited in duration and scope. So it doesn't provide ongoing authority to somebody to make decisions on behalf of someone else. But the court may say, for example, I'm going to allow you to make a decision for them about this particular medical treatment. And that's it. That's all the authority. Or I'm going to allow you to access their financial information to help them apply for this particular public benefit program that they need. And that's it. This is an ongoing authority. So those are both options that are there that might provide families with a bit of reassurance if they haven't filed for guardianship or conservatorship right after the person turns 18. Next slide.
Thanks, Kate. So Kate has really, throughout her presentation about guardianship and conservatorship, talked about these less restrictive alternatives that the court requires you to consider. And that's what I'm going to talk about now, is options that do not require you to go through court and might actually be suitable for the needs of your young person. And that in most cases, you are required to try to see if they'll work before pursuing an option like guardianship or conservatorship. So I'm going to be talking both about durable power of attorney as well as another option called supported decision-making agreements. But first off, I'm going to kick off with durable power of attorney. So durable power of attorney is a document that lets a trusted person take actions or make decisions on behalf of the adult with disabilities. In a durable power of attorney, the trusted person or relative making the decisions is called the agent, and the person they're taking actions or making decisions for is called the principal, and the principal is the person with the disabilities. The principal must have the capacity to understand what it means to sign the durable power of attorney. They do not have to understand all the legal terms, which means that they do not have to understand kind of every single word and legal terminology that's used in the durable power of attorney. But they do need to understand the basic concept of the durable power of attorney, which is, for instance, my parent who has always been helping me with these types of decisions, I'm signing this document And this parent is still going to be able to make these decisions for me now about, like, say, these medical decisions. And that's kind of what it means to have that understanding of what the durable power of attorney is, and the sort of capacity that the person with disabilities needs to have in order to execute, meaning kind of make legal and sign and everything, that durable power of attorney. The word durable in the power of attorney means that the power of attorney stays in effect even if the principal loses capacity. So if the person has that capacity now to understand the durable power of attorney and what they're signing and what they, for instance, are, you know, asking their parent to, like, make certain types of decisions for them, if their capacity becomes less in the future and they no longer would have capacity to kind of understand what the power of attorney means, or what they agreed to at the time that they signed it, it will stay in effect even when the principal loses capacity, as long as they had capacity at the time that they signed it. Um, a question that we do get sometimes is, well, is a durable power of attorney, does it go into effect immediately, like right when everyone signs it, or does it only go into effect at that point when the principal loses capacity and they can't make their own decisions anymore? And the answer is it can be either. Um, in the durable power of attorney document, you can specify whether you want it to be taking effect immediately, or if you want it to take effect at a later date, such as when the principal loses capacity. It's important to note that as long as the principal has capacity, the principal can still choose to make their own decisions. So let's say, for instance, that the principal and the agent are at the doctor, and the agent, makes some sort of decision to the medical provider, and the principal, the person with disabilities, says, "Oh, no, no, actually, I choose this other thing." As long as the principal has capacity, their wish and what they want still overrules the agent, as long as as long as they have capacity when they're making that decision, even though there's a durable power of attorney in place. And it's important to know as well that the principal can cancel the durable power of attorney as long as they have capacity. So the durable power of attorney is not in effect forever. The principal can decide at any point when they have capacity that they no longer want the durable power of attorney to be in effect. And very similar to the guardianship and conservatorship orders that Kate was discussing, that can be really tailored to the needs of the person with disabilities, in terms of it can be for some decisions and not others, or very kind of specific situations. That's the same with a durable power of attorney. It can really be fit and changed, even though there are some standard forms that I'll talk about in a second. It can be fit and changed to really meet the needs of that specific situation. So again, it isn't necessarily a one size fits all. It's really what the principal thinks that they want help with, what sort of decision making power or actions they want the agent to have, and so it can be very, very individualized in that way. So a durable power of attorney is a legal document, and as a legal document, there are certain requirements that the durable power of attorney must have in order to make it comply with the law. So the first is that it must be in writing, and then the second is that the durable power of attorney must be either witnessed or notarized. And what do those words mean? So, under the law, witnessed means that two people who do not have, like, a personal stake in what's going on in the situation, they're just there and they've signed the power of attorney themselves too, saying, "Yep, these two people are who they say they are. I know them and I agree. It was them who signed this document." Um, A notary is a witness, but a notary is someone who has an official certification through the state to be sort of an official witness. And they have a stamp. They check everyone's photo IDs. They really kind of check everything out to say, yes, indeed, I am not involved in this at all. I'm an uninvolved third party. I have a certification from this state that says I'm a notary. I have a stamp, everything like that. I've checked this all out. And yes, everyone is who they say they are and that there's no fraud. And they watch as everyone signs the document as well. We really recommend that if at all possible, that you have your durable power of attorney be notarized instead of just witnessed, primarily because your durable power of attorney, and this is more of a practical matter than a legal matter, is going to be taken more seriously by third parties like doctors, banks, schools, etc., like that, at least in our experience, if it is notarized rather than just witnessed. Another good thing to know about durable powers of attorney is that they are not filed with the court. So, different from guardianship and conservatorship that Kate was talking about, where everything is through court and that court process. Instead, this is just a document between the agent and the principal, or in some cases, two agents, because in fact, in the power of attorney document, you can specify that there are two people who can actually be the agents, but it's not filed with the court. And so you make photocopies, you take it with you when you go to doctor's appointments, to the school, whoever it is who needs to know that there is a power of attorney in place. The photo, the photo or the little template there that you see on your slide of that durable power of attorney, that's from the Washington Law Help website. And you can find a link to that on the resources slide at the end of this publication. And then there's also a link to this durable power of attorney template on the webpage where this video was posted. So I'm going to turn now from durable powers of attorney to supported decision-making agreements, or SDMAs. A supported decision-making agreement is an agreement between a person with disabilities and a person or people who they choose to help them, and these helpers are called supporters. The person with disabilities chooses what help the supporters give them. And the supporters can help a person with disabilities get and understand information and communicate their decisions. The supporter does not make decisions. They help the person with disabilities make their own decisions. And this is really an important difference from the power of attorney, where the agent may be making some decisions because the principal said that they could. Instead, a supported decision-making agreement is about really helping that person with disabilities to be able to make their own decisions. And to kind of step back a little bit, kind of that 20,000-foot view. So supported decision-making agreements were put into law in Washington State in January 2022. At that same time that Kate said that there were a lot of changes to the guardianship law, and they were put in place in order to really give people with disabilities more tools to help them have capacity and help them make their own decisions in situations when that was appropriate. So if we look back at that definition of capacity from the beginning of this presentation, which is someone needs to be able to kind of take in information, understand information, make decisions, and then communicate those decisions to other people, you can see here in that third bullet point that supporters, really what their role is, depending on kind of what that individual person with disabilities need, their role is to really help that person at kind of those different elements of capacity to be able to make those decisions on their own. And that's really what the purpose of a supported decision-making agreement is. Because supported decision-making agreements became a part of the law they have legal requirements in order to be official or recognized or kind of legal, the same way that durable powers of attorney do. So the requirements for supported decision-making agreements are that they must be in writing, they should be notarized or witnessed. And again, we really recommend, if possible, for the same reasons that we recommend that durable powers of attorney be notarized rather than just witnessed, that supported decision-making agreements also are notarized. And just like with durable powers of attorney, supported decision-making agreements are not filed with the court. Instead, you make a photocopy and then or the original, and you show it to third parties like medical provider school, whoever might need to see it in order to understand kind of, okay, why are the supporters here, what sort of support are they offering, how does this work, that sort of thing. And then just like the durable power of attorney being on that Washington Law Help website listed on the resources slide and available on the webpage where this video was posted, so are supported decision-making agreement templates and more information about supported decision-making agreements and durable powers of attorney and all of that. A lot of really, really helpful resources there.
I'm wondering if you could speak to whether those supported decision-making agreements can be used for things like financial decisions and managing money, or are they just for decisions about medical or personal care?
Really good question, Kate. And you and I both know that this is kind of coming up more and more, especially as these supported decision-making agreements are starting to be used. And another question that we get often is, can someone have both a durable power of attorney and a supported decision-making agreement at the same time? And the answer to that question that's there on the slide is yes, you can have both, but they have different goals. Because remember, the durable power of attorney is about appointing an agent to make some decision or take some actions, whereas the supported decision making agreement is really about support for that person with disabilities for them to make their own decisions. But on this question of particularly banks, financial institutions, that sort of thing, yes, absolutely, technically, and especially it's part of the law now, these supported decision-making agreements and entities, like banks, schools, medical providers, all of those, it's part of the law that someone can have a supported decision-making agreement and that really the third party should be respecting this. However, kind of what is in the law, and then really the practical side of it, especially when you're dealing with entities and pretty conservative institutions like banks that are dealing with a lot of money, a lot of regulations, that sort of thing, especially because supported decision-making agreements really just went into effect so recently in January of 2022. We're finding that a lot of them have just not really come across it before, really don't understand what it is, may not be as comfortable with it. And so in practice, and in a second, Kate, I'm going to ask you a question because I know that you had some experience with a relative and a durable power of attorney, and it's again kind of what's in the law and then kind of in practice making things work. But you may want to have a durable power of attorney, a supported decision-making agreement, and maybe also a release of information form, kind of covering all your bases so that then you run into the least amount of problems with the third party that you're dealing with and trying to kind of get them to accept these different documents in order to resolve whatever problem you're kind of trying to resolve. Kate, can you talk a little bit more about that experience that you had with that relative and the durable power of attorney?
Yeah, I would just say that in this case, it was dealing with a bank. I had to jump through quite a few more hoops than I had realized. And in particular, the bank was very concerned with me being able to prove my identity. And I mean, it worked out fine in the end, but I think that thing to keep in mind is that you do have to be flexible. There's what the law says, but these institutions have their own policies. They're there to protect their customers and also for legal liability. And so, just to know that it requires some flexibility, and you have to be willing to work with that.
Thank you. And so to summarize, this is really kind of the difference between that durable power of attorney and those supported decision-making agreements that we've talked about before. And I'll say we also do get the question is, let's say that you do have the durable power of attorney and you have the supported decision-making agreement. They're actually working, and maybe there are some hiccups like you were just talking about, Kate, or something like that, but they're working. You have things in place. Do you need a guardianship too? And this kind of gets to that basic question of the less restrictive alternatives. And the answer in that case would be no. You should not have a guardianship or conservatorship if you have these less restrictive alternatives that are working, because that means that the person with disabilities has the capacity to make their own decisions and to kind of be deciding for themselves about, I need support in these areas to make my own decisions, or maybe in this other area, I want my agent to make some decisions for me. But the less restrictive alternatives are working. And so therefore, guardianship or conservatorship would not be appropriate. I know that another question that we receive about these sorts of agreement, like the durable powers of attorney and the supported decision-making agreements, is when trusted adults or supporters, the person who might be the agent, are worried about really specific situations, like maybe picking up prescriptions or being able to make medical appointments or other like very specific situations. And as we talked about a little bit before, just like guardianship or conservatorship orders can be tailored very specifically to that person's situation, and the durable powers of attorney can as well, and supported decision making agreements. You can also add in, there are those templates on the Washington Law Help website for the durable powers of attorney and the supported decision making agreements. And I think in practical experience, again, it seems like for most people, they're able to do what they need to do, even using those templates. But you can add in some specific language too, and kind of tailor it to your situation if you know that there are specific things that you're worried about, like picking up prescriptions or making doctor's appointments or things like that. So I'm now going to cover other options for decision making and managing finances that you may not be as familiar with. So we've talked about conservatorship, we've talked about guardianship, we've talked about durable power of attorney, we've talked about the supported decision making agreements, and then these are kind of two other things to be aware that are non-court options that help with decision making in some areas, instead of going to court. So the first there on the left side of your screen is Washington State's Informed Consent Statute, which is a law that allows medical providers in Washington State to accept consent to medical care from people listed in the state law if an adult does not have the capacity to consent to their own care. And what this relates back to is, if you remember, Kate was talking about that situation where we often see this is when a young adult with disabilities has turned 18 and parents or another trusted adult are really worried about, what kind of happens at that stroke of midnight. And we find that medical providers often will rely on this informed consent statute in order to let someone on this list that is listed in the law to make medical decisions and kind of continue to make medical decisions for that young person, probably as they kind of always have in the past. So there's a list, and it's a hierarchy, meaning that people who are higher up on the list have kind of um, uh, their decisions would be taken over people who are lower on the list. And there are a guardian and conservator is listed, then a durable power of attorney. But if someone does not have those people, and if they do not have capacity to consent to their own care, then the law says you can turn to certain relatives. So I won't go into the details of kind of who's who and the whole thing, but no, it's kind of like spouses and registered domestic partners, and then it goes down to adult children. It goes down to parents, siblings, that sort of thing. Something important to know, and I'm just noting this because Kate and I know that people are often surprised, and honestly, we're a little surprised too. The informed consent statute does not allow grandparents to consent. And so just know that they are not kind of these decision makers in the law. Um, in practical terms, we really find, as I said, that medical providers really commonly use this informed consent statute in that kind of continuity of care scenario that we were talking about before, in kind of routine care. And then sometimes if there's some sort of an emergency, and like just someone needs to be able to make a decision in the moment, and maybe there isn't even time for kind of that emergency guardianship or whatever, they'll turn to that list and say, okay, well, in this moment I need to take consent from someone on this list who can make those decisions. We find medical institutions, and again, this is just kind of our professional experience, to be less likely to rely on this informed consent statute and to instead want one of those other types of options that we were talking about before, in situations where maybe there's a planned surgery or some sort of a planned procedure or something. So there's like a little bit more time, but maybe there's anesthesia, or maybe there's something that just makes it a little bit more risky. So they just don't feel quite comfortable relying on the informed consent statute in that situation. But it's a really powerful tool, and it's good to know about just as something that is there in those situations where it can be useful. Then turning to representative and protective payeeships. These allow someone to manage the government benefits of an adult who can't manage their own benefits. And by that, we mean what we're really talking about there, most commonly, is when an adult with disabilities is receiving supplemental security income, or SSI, which you may have heard of, through the Social Security Administration, which is a cash benefit, or else there are similar cash benefits through a state agency, a Washington state agency called the Department of Social and Health Services, or DSHS. And what these representative and protective payee processes are that they're actually a process and form through those government agencies if they don't think that the recipient of the cash benefits can really manage their own benefits, meaning spend it safely, make sure that there's enough money to meet the person's basic needs, like shelter and food and that sort of thing. And they're like, oh, we're a little concerned, probably someone else should be managing these benefits and making sure that this person can be taken care of, can be taken care of. And it's really an alternative then to like conservatorship or whatnot like that, because there's no court order needed. Instead, it's really just a process of working with that agency, either the Social Security Administration or DSHS. They have their own processes, forms, everything like that to get set up then as a representative or protected payee, so that then that person's cash benefits are safely managed and their needs can be met by spending those funds and benefits.
Great, thank you, Ashley. So we're coming to the end here of the presentation. This is a slide that shows various resources that we think would be helpful for folks. Just to be aware, there are resources on guardianship and conservatorship and alternatives on the webpage where you access this video. And so the link to that is at the bottom of this slide. And then in addition, we've listed WashingtonLawHelp.org, which is a website that Ashley referenced. This is maintained by Northwest Justice Project, where we both work. And it's a website with self-help legal resources for the public. And it includes a whole range of resources, including publications on durable power of attorney and support decision-making agreements with sample forms in them that you're welcome to use. And many of the resources are available translated into other languages. So we encourage people to take a look. The second resource there is the website for the Arc of Washington. They also have some really wonderful resources, particularly related to guardianship and conservatorship, but decision-making generally. And then the last resource is for the Washington Courts forms page. So if you're looking for those forms to file for guardianship or conservatorship, that's where you'll find it. The Washington Courts webpage generally has a lot of really helpful information about guardianship more generally. And so we do encourage folks to take a look at that to learn a bit more if that's something that they're interested in. Next slide. So we are very interested in people's feedback about the class. We appreciate if you can take a few minutes to give some feedback so that we can evaluate this video and see if it's helpful. You can use the QR code on your cell phone, or you can also email feedback to that email address at the bottom of the slide.
Great. Thank you so much, everyone, and thanks for joining us today. Take care.
Thank you.